So the issue of concealed carry bans and a state's direct defiance to the Bruen decision, and also a circuit court's express defiance to that analysis, is now back in front of the Supreme Court for review. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Brownells. You guys all know that Brownells is an amazing company. They do a lot for the 2A cause. They sponsor this channel. They support what we do here, spreading the 2A news and 2A information. Again, check out Brownells. They're an amazing company. They have amazing employees and people over there. I cannot recommend them enough. And thank you again to Brownells for supporting this content. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans, expressly the one out of New York, is once again back in front of the United States Supreme Court. You may recall that the Supreme Court recently granted, vacated, and remanded this case, Antonyuk, back down to the Second Circuit for a new decision in light of what they said in the 8-1 decision in the Rahimi case. The Antonyuk case challenges the state of New York's new hyper-restrictive concealed carry law that they passed just 8 days after the Supreme Court issued Bruen. The Second Circuit issued a new decision on concealed carry bans, and essentially they reissued the same decision. They found that Rahimi did not change the outcome of the case at all, and also they found that the Bruen analysis really didn't apply to this type of concealed carry ban, that they didn't have to follow what the Supreme Court said in Bruen, and also that Rahimi did not establish that they have to follow a certain type of analysis. So in response to that horrible decision, the plaintiffs here in this Antonyuk case, supported by GOA, have now filed for Supreme Court review, and this is heading back in front of the Supreme Court. And this is important because it deals directly with a state like New York, directly defying Bruen, passing a concealed carry ban, and also involving a circuit court who is expressly denying what the Supreme Court said and not applying their analysis. Now, this issue of concealed carry bans, especially in states like New York, has been a long battle, and expressly this one in New York should have ended after Bruen. In Bruen, the Supreme Court struck down New York's prior original May issue CCW licensing scheme, and they found that it was inconsistent with this nation's history and tradition. However, despite that, like I mentioned, New York passed the Concealed Carry Improvement Act, and they did that just 8 days after the Bruen decision. That law was challenged in multiple cases. There were preliminary injunctions that were granted against the CCIA, halting its enforcement. There were then appeals up to the Second Circuit Court of Appeals. And the Second Circuit at that time, of course, because they're liberal and they are biased against the Second Amendment, they granted blanket stays against those decisions and allowed New York to still enforce the CCIA. However, in response, GOA in the Antonyuk case for the first time sought emergency review from the Supreme Court. The Supreme Court denied emergency application and review in those cases, but we did get a statement from Justice Alito saying that the Second Circuit could not drag their feet on this issue. They would need to expedite review in these cases, or at the very least, issue an order or some sort of statement justifying why they were granting blanket stays. Now, the Second Circuit didn't want to do that, so then they held expedited review of these cases. At that time, there were 5 consolidated CCIA cases, and the Second Circuit heard oral arguments in those cases. Now, again, the Antonyuk case, in my opinion, was kind of the biggest one of all those because it was a little bit more comprehensive in what it was challenging. It was challenging the whole permit scheme and that permit process, but also some of the catch-all sensitive location schemes that were put in place, dictating where and when you can carry concealed, even with a permit. Now, on review, the Second Circuit ultimately vacated some of those preliminary injunctions that were granted by the lower courts, so ultimately the Second Circuit sided with the state of New York. Now, in their decision, this is where the Second Circuit got it wrong and was directly defying Bruen. They said that Bruen was an exceptional case, and since Bruen was an exceptional case and Antonyuk and these other cases were not, they didn't really have to apply the Bruen analysis. Now, in response to those Second Circuit rulings, GOA then filed their second petition for emergency Supreme Court intervention. Although that case was still in an interlocutory posture, the Supreme Court did actually GVR, which means that they granted, vacated, and remanded this Antonyuk case back down to the Second Circuit for a new decision, a new analysis in light of their 8-1 decision in Rahimi. Because Rahimi was the new Second Amendment case upholding the domestic violence restraining order federal laws, but they used the same type of analysis that was used in Bruen. So they reestablished once again that Bruen is the Second Amendment analysis, and that should have sent a strong signal to the Second Circuit that they could not just simply avoid applying the Bruen analysis. After that Supreme Court GVR of the Antonio case, the Second Circuit opened the case back up. At that time, they had supplemental briefs and other things submitted to them. And originally, the Second Circuit was intending to actually have re-review of a bunch of those consolidated CCIA cases. But then they actually said, no, they were only going to proceed forward with the Antonio case because that was the only case that was GVR'd by the Supreme Court. And ultimately, like I mentioned, the Second Circuit issued a new decision. And what they found was that Rahimi, again, did not change the outcome of their decision. They kind of stayed true to their position that the Bruen analysis and the Rahimi analysis really didn't need to be followed, closely, that they could have a bunch of wiggle room and essentially rule the way that they wanted. The Second Circuit stated in the opinion that having reconsidered the prior decision in light of Rahimi and the parties' supplemental briefing regarding the effect of that decision on our reasoning in this case, we now issue a revised opinion in Antioch. We reached the same conclusion that we reached in our prior consolidated opinion. Accordingly, they just simply reaffirmed their same ruling and almost the same judgment that they had before. So in reality, nothing changed in that decision. They issued a new 246-page opinion, that came out of the Second Circuit in the Antioch case, but simply they were reinstating the same opinion, saying that, okay, we looked at this in light of Rahimi, we don't think that it changed anything. But now really all of this is coming to a head and it's heading back to the Supreme Court. And the plaintiffs here through GOA have now filed for Supreme Court review. Their petition has been filed. And again, they're asking for the Supreme Court to reverse what the Second Circuit said. In the petition, GOA argues that repeatedly, the panel asserted that it was not bound to apply Bruen's methodology, surmising that Bruen was a case of exceptional nature, and courts maintained flexibility when examining less exceptional regulations. The panel repeated this claim no fewer than 4 times to justify its circumvention of Bruen's framework. The panel cited to a law review article that labels Bruen unsatisfying, claims Bruen placed outsized importance on historical silence, and suggests judicial responses to the decision in order to read Bruen narrowly, and engaged in the time-honored practice of narrowing Supreme Court precedent from below. If Bruen left any question unanswered, Rahimi laid them to the rest. Contrary to the panel's insistence that Bruen was an exceptional case, warranting uniquely heightened historical stringency, Rahimi confirmed that Bruen simply explains the appropriate analysis. Thus, Bruen and Rahimi established the norm and do not permit a more nuanced approach whenever a court declares a challenge regulation to be less exceptional. But the panel read Rahimi differently, casting it aside as having little direct bearing despite being the reason behind this court's remand. So this petition by GOA to the Supreme Court not only outlines the clear Second Amendment precedent that should find that this New York Concealed Carry Improvement Act law is in fact unconstitutional, but GOA also is showing the Supreme Court directly what links the Second Circuit went through to actually defy what they said in Bruen and Rahimi, and how they are trying to circumvent the analysis that was established in those cases. This new petition sets up a critical review of a state's hyper-restrictive concealed carry ban and also the laws that were passed in direct defiance to what the Supreme Court said in Bruen. This case also shows a very clear example of how circuit courts like the Second Circuit are directly defying the analysis that was set out by the Supreme Court in cases like Bruen and Rahimi. So this is a very important appeal, a very important petition up to the Supreme Court. This is again a case the Supreme Court is very familiar with. They GVR'd in light of Rahimi. This is an issue that's made it to them before. This is a case that deals directly with New York's carry bans that were struck down in Bruen, and then a new concealed carry ban that was passed just 8 days after Bruen. So again, a very critical case, a case that has a lot of implications for other states as well, but also just is one of those perfect cases to show the Supreme Court all the shenanigans that are happening at the lower court level, and also what states are doing to directly defy the Supreme Court. So as this develops, as we get more information, I will let you guys know. I just want to make you aware of this because this is a very important petition. If we get any more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.